Yes, Mr. Fry.
My Lords, good morning. My name is Mr. Fry. I act for the Secretary of State in this appeal.
Yeah.
My learned friend Mr. Rudd acts for the respondent, Mr. Rogers.
Yes.
My Lords, housekeeping to start. My Lord should have a core bundle and a supplementary bundle, which was resubmitted on the 4th of November,
Yes.
2024. Grateful. You should also have an authorities bundle,
We do.
now agreed between the parties. And there was an email sent late last night. It was my error, my Lords. The pagination had failed on the PDF document that had been sent to my Lords. One with page references has been submitted now, but no hard copies are yet available. My Lords need that. I can get those arranged for him.
I think I've compiled a bundle, but I haven't paginated it all. My bundle, which is the original pagination, I think goes up to 209. And then the additional authorities, I just simply put in the front.
My Lord, if you've been using the PDF references, then you're
I probably have.
point. That's exactly what I've been using.
I'm sure we'll navigate that all right when it comes to it.
I'm very grateful. And then,
yes.
with apologies, my Lord, there's one more authority that I seek to hand up. It's Court of Appeal Authority, Carnegie and Drury. It just deals with a single point, which is what the court can take into account when determining reasonable steps, i.e. is it after the deadline or pre-deadline. It's a very neat point. I'll take my Lords to it in due course.
Sorry, what was it called?
Carnegie and Drury, my Lord.
And Mr. Rudd is aware of this?
Only as of about half an hour ago, my Lord.
Right.
I
Well,
have copies, my Lord.
we'll have to make sure that Mr. Rudd has an ample opportunity to read that.
Of course, my Lord. May I hand up the authorities?
Please.
It'll be a while until I address them, my Lord.
Yeah.
Lastly, my Lords, you should have replacement skeleton arguments
We
from
do.
from both parties.
We do, and that was in accordance with directions I made last week. Thank you. I think.
I think that's right, my Lord.
Yeah. So we'll put this additional authority, Carnegie and Drury. I'll simply put it in front of my authorities bundle.
Right, my Lord.
That's where I'll find it.
That's all I had.
All you had was two things I have. This courtroom does not feel warm. Does it feel uncomfortably other than warm?
My Lord, I'm perfectly...
Maybe I've been in
look at my learned
a
friend.
warm
I'm
environment
warm.
until now this morning. It doesn't feel very comfortable. If it becomes uncomfortably cool or even cold, then we must do something about it. So I'm just mentioning that now, so the associate may be able to do something to help us. Yes. Well, maybe polite but regular chasers would be a good thing this morning.
No, I shall warm up as soon as we finish.
Well, I hope we're not going to be uncomfortable. We'll do everything we can here to ensure that we're not. And the other thing is to mention that because one member of the court has a commitment in the middle of the day today, we're going to stop no later than 1 this morning and resume no sooner than 2 this afternoon. But I don't see any prospect of difficulties over time with this appeal.
No, my Lord.
So that's, I think, all from us.
My Lord, I'm grateful.
I think.
The last thing to mention is, may I just offer my instructing solicitor's apologies due to the trains this morning. She is running late, and we'll tuck in behind when she arrives.
Thank you very much for that.
But I'm grateful. These submissions are going to be structured as follows. First, I wish to address the correct test.
Yeah.
Second, matters of background and agreement between the parties. And then I simply wish to address reasonable steps and promptitude, promptness, depending on how one wants to phrase it as a last stage, and wrap that up to come back then into my grounds, my Lords.
Yeah, like, I've got a question which may be, in a sense, a false question, but I'd just like to get it out there. This appeal is on two grounds. Does it need to succeed on both grounds for it to succeed, or can it succeed on only? Can the appeal succeed if only one of the grounds succeeds? And there's not an automatic corollary to that, I don't think. So is that something you're ready to answer now, or would like to reflect on? It seems a bit. It sounds a basic question, but it may require some unpacking. I'm not sure.
Well, I'll think about it further over the course of my submissions, but my immediate response is no, I don't need to succeed on both grounds. In the first ground is essentially taking into account immaterial considerations, irrationality. The second is frankly similar, but in respect to a different factual basis for the judge's finding. And my lords, I'd submit that if the court is with me in either of those, the court's entitled to substitute its own opinion of the facts. If one finds that the judge has acted irrationally with respect to the learned judge, then the court's entitled then to look into it. My lord, if it insists, I will take the court to good law and exactly what the appellate court can do in these circumstances. But
I think that will probably help us. But take it in your flow as you go along, if you would, please.
Well, given its fundamental nature, it might be one to address at the start.
If you feel ready to do it now, otherwise come back to it.
Well, I thought that the court's what the court might do in the circumstances might be an issue that came up. So let me address it now. In that, my lord, good law is at tab 7 of the authorities bundle. I'm looking at page 131, which is paragraph 37. Good law.
Yeah. Just a second. Thank you.
Paragraph.
37, my lord.
Yep. Your page numbering works.
131. I'm very grateful, my lord, for that. That of it as well.
So it does.
So, my lord, I'm relying in particular on the first two sentences of paragraph 37. My lord, I think the parties agree that this is a discretionary order made by the judge, and so in order for the court to intervene, this court has to find the judge erred in principle was wrong.
Yeah.
And my lord, the second sentence is to draw the court's attention. There is a generous ambit within reasonable disagreement is possible. My lord, simply disagree, but accept that the judge considered the right facts and applied the right test, then the court should not interfere. But if the court thinks that the judge was wrong, then the court should interfere. And the way my grounds are formulated is that the judge was wrong in her conclusion in respect of service of the sealed claim form and the matters she took into consideration. And the second is the failure to consider the prejudice of the Secretary of State, which is essentially a promptness point. So, my lord, I'll take my lords to the relevant test, but the test is a conjunctive test. There's an and in CPR 7.6. So I say if I succeed on either of those, I should be successful depending on what the court thinks about the wrongness or rationality of the judge's decision.
Yeah.
Well, while we're in good law, it might be worth asking the court just to turn over leaf to make the obvious point, paragraph 41, as to the importance of the claim form and valid service that this court has found. I don't think that's controversial either between the parties. My lord, is that a sufficient answer for now to
Yes.
my lord's question? I'm grateful.
It is, thank you.
The second point, addressing the relevant test, my lord, as the court will appreciate, this appeal was lodged over a year ago, and in circumstances where there wasn't a lot of first instance authority, and that position has changed considerably in the intervening period, hence the replacement skeleton argument. And my lords, the preliminary issue is essentially that the test that's now been adopted at first instance, and the references of my skeleton, I don't propose to take my lords to it unless you wish me to, is that there are now 4 or 5 first instance authorities which set out the test, namely CPR 3, but applying by analogy CPR 7.5 and 6, and there appears to be nothing between the parties in that regard in this appeal. My Lord, it's 6 first instance decisions actually which set out the principles to be followed, and then at paragraph 27 of my skeleton argument, again, my Lords, I don't think we need to turn it up now, but it's just for your reference, I've set out CPR 7.63, which again I think between the parties is agreed to be the relevant test that was before the judge and before this court now.
Yeah.
And so, my Lords, if the court agrees that the test at first instance is correctly stated, it follows that this appeal is one in which the court must be satisfied that the judge below was wrong in approach as opposed to test. And that's in respect of whether the claimant had taken all reasonable steps and as to whether the claimant acted promptly in making the application to extend time. And as I indicated in response to my Lord's question, CPR 7.63 has a conjunctive and in my submission. The first, CPR 7.63 is divided into 3 subsections, my Lords. The first is when the court has failed to serve the claim form. That isn't part of this appeal. The second is whether the claimant has taken all reasonable steps to comply with Rule 7.5 but has been unable to do so. And C, in either case, the claimant has acted promptly in making the application.
Right.
So, my Lord, that is the test. And unless my Lords want me to go through the first instance authorities, you have in Farnham Town Council, again with respect to the judge, a pithy analysis of the relevant authorities, drawing in each of the precursor first instance authorities to describe the test which I've just set out to my Lords. I don't think it's controversial now, first instance, in my respectful submission.
No. 2 things, I suppose. First of all, is that agreed? I think you've made that explicit probably. That is agreed that the Farnham Town Council approach is a true approach. Is that right?
Yes, my Lord.
Yes.
Yeah. And secondly, being facetious at all, is good law good law? Is that agreed or not?
My Lord, I'm not sure if good law is agreed. I'm presuming so. Within the ambit of this appeal, I'm sure my learned friend isn't going to accept everything in good law, having not read it in that light, my Lord. But
no, but I mean, are we bound by good law in any sense?
yes, I think you are, my Lord, in that it deals.
That's common ground, is it?
With the point, my Lord. I'll turn my head. I think it is common ground, my Lord. Again, within the ambits of this appeal and applying all the first instance authority.
I think that's the point. Not everything in good law is necessarily relevant. So, to the extent that it is applicable, it is agreed that this court should follow good law. You'll see from the relative skeleton arguments, we don't dispute that point.
No, fine. All right, that's very helpful, Mr.
I'm very grateful.
Thank you. Right. Yes.
So, Lord, as I say, I don't think I need to trouble the court with the test. There's nothing before the court to indicate that there's any other test than the good law test as applied by Farnham Town Council. And say it's been now applied at first instance 6 times, and this is the only appeal which has come before this court, so far as I'm aware.
Right.
My Lord, that's all I wish to say about the relevant test. So turning to background and agreement, again, there is considerable agreement between the parties in this appeal, which is a fairly rare occurrence, but the background is largely agreed. It's the effect of the actions taken over the course of the proceedings in the application of the test which is in dispute between the parties. And then in that respect, my lord, if I could ask my lords to take up my skeleton argument,
Yeah.
at paragraph 13, there is a chronology set out.
Yeah.
Again, my understanding, my lords, is it is an agreed chronology.
Right.
And there are certain key dates that I just wish to draw to the court's attention. Firstly, my lords, serial 1, you'll see the decision date was the 23rd of March 2023. Serial 2, you'll see that the respondent filed the Part 8 claim form with the court on the 18th of April 2023. Serial 3.
Yes. I'm sorry. I should have raised this at the outset.
Of course,
Actually. Do we have? There was a mistake, wasn't there, in the claim form that's submitted? Sorry, that's very imprecise language. The wrong claim form was submitted.
My lord, it was a point that was taken. Frankly, I'm not sure how much we'll turn on it in this.
Do we have the claim form?
You have, my lord. It's at page 85 of the core bundle.
It isn't though, is it? 85. Because 85 is the one that was sealed on the 15th of June. And I thought that was the section 289.
My lord, let me check.
85 is a CPR Part 8 claim form. And it's date stamped.
Yes,
15th
my lord's quite correct.
My understanding is there were two claim forms, is that right? One for the 289, one for the 288.
That's correct, my lord.
And what we're interested in is the 288.
288 claim form.
I haven't been able to find that,
You're absolutely right.
even though it's potentially the most critical document in the case.
Do you think, Mr. Fryer, that could be on the to-do list for
My
your
lord,
instructing solicitor when they arrive?
it is on the to-do list, my lord, and I'm embarrassed to say that I did check this point and took it as read. So what I will do is I'll make sure the court has that.
I meant to raise this at the outset and failed to do it, but my lord has just identified the gap in our materials.
Yes, my lord. I will. When I sit down, I'll have a look. I think it might actually be in the supplementary bundle behind the witness statement. But my lord, don't rather than go on a wild goose chase now on a vague memory. Let me sit down at a convenient time and try and.
All right. Well, it needn't impede us now, but we do need to get that.
Yes, my lord.
And you were, we interrupted you because you were saying that on the question of the quotes wrong form, you weren't sure that that was necessarily a point you maintained.
Well, my lord, it's a point to go into the mix potentially, but it isn't going to be determinative of this appeal. The Secretary of State doesn't take issue with the fact that a claim form was filed with the court at the relevant time on the 18th of April 2023. What potentially falls out of the incorrect form, so far as it goes, is that the Manchester Court Office wasn't aware that it was a 288 claim potentially.
Yeah.
But my submission would be that and we'll need to look at form, my lord, if it says 288 on it, that's sufficient to put the court on notice of the 288 claim. What falls out of that?
So it's really all superseded by your related point that they didn't identify that what the time pressure was that when the period expired, which is a point you make.
Yes.
And is a point open to you, and that doesn't turn on the right or the wrong claim form.
That's absolutely correct, my lord.
Yeah.
And I'll go into it very shortly, my lord, but that is essentially the crux of this appeal and the dispute between the parties. If what was done was sufficient or not, applying the test that I've just outlined to my lords.
Yes. So the kernel of the appeal is shortly described in that way.
I think that's right, my lord. It's why I'm hopeful that we can deal with all the points before my lords need to rise. I don't think there's anything hugely controversial. It is a fact-based analysis that the court will need to take out, but that fact then relies on the discretionary application of the relevant principles to the test. So,
Understood.
my lords, I was going through the chronology, and I just, for my lord's note, I'm not going through each. It appears that I am, but I'm not going through each of the serials. It's just the key serials in my respectful submission that I'm bringing to the court's attention. The next serial to look at is serial 4, the 4th of May, 2023. Again, it's agreed between the parties that that is when the 6-week time limit to file and serve the claim expired. And my lord, again, not controversial between the parties that it's filing and service that has to be carried out within the 6-week window, applying all the authorities that my lords have been referred to. Then skipping through the serials, the next one to draw the court's attention is serial 16, 4th of July 2023. The Secretary of State writes to the respondent, noting that service of the Section 288 sealed claim form would be significantly out of time. Then, my lords, serial 20, 11th of July 2023, the court issues the sealed claim form for the Section 288 application, and that's the sealed claim form that the court has asked for, and I will seek to find. And then overleaf, the last two emboldened serials, 21 and 22, are the final steps in this element, my lords. 12th of July 2023, the respondent served the Secretary of State with the claim form. And my lord, just above that in my skeleton argument, you can see that on the 11th of July, the respondent attempted to serve the Secretary of State but failed. At the bottom of the box of 20, serial 20. And then lastly, my lords, serial 22, 13th of July 2023, the respondent makes the application for extension of time to serve the claim form.
Yep.
So, my lord, given the agreement and between the parties, and as I indicated, my lords, the dispute is essentially going to be a factual dispute in the application of those facts. I'm going to turn to the reasonable steps test now and adopt the slightly unorthodox approach of dealing with what is said against me in making my submissions, because I think that does clarify the correct position. So, my lord, what's said against me is that the issue is the court officers and not the respondents. The respondent says, I filed the claim form, I chased it, I didn't get it, therefore it's not me, I took all reasonable steps. And the judge below found favour with those submissions. My lord will have seen in the bundle there's a case, Merrill's, which is at page 59 of the bundle, and my lords will have noted that the judge below in this appeal is the same judge as gave judgment in Merrill's. And if I could ask the court to turn up Authorities Bundle 63, which is Merrill's, paragraph 15. My submission there is that the position was very similar. I've set out slight differences in my skeleton, and my learned friend set out further points of distinction. But the point is that the claimant was unable to serve the sealed papers on the defendant within the statutory 6-week period due to the court not issuing the sealed papers until expiry of the time limit. And then while the court is in Merrill's, if I could ask my lords to turn over leaf to paragraph 28 on Authorities Bundle 66. The court there addresses what could have been done in terms of reasonable steps, and mentions there attending in person, impressing upon the court the need for for a sealed claim form in terms at 29. My Lords will see the last sentence of paragraph 29. The learned judge accepts the point made for the Secretary of State that it might be inadvisable for the representatives to have said to the court staff in terms, we require a sealed claim form prior to 4 p.m. on the 15th of June to enable us to serve the other parties. My Lord, it was the same issue in Telford, which is another one of the first instance authorities, and if my Lords could turn up authorities bundle 96, paragraph 46, my Lords. Again, my Lords, if I start reading from about halfway through that paragraph, the submission was made to the court that it ought to have a system in place to handle claims promptly and urgency. And the submission was made to the court, this should be the position even if the need for urgency is not flagged up by claimant or another party. So that was the position, and then my Lords turn to paragraph 54, where the court considers that point.
Yeah.
It's directly addressed for authorities bundle 98, my Lords, in terms of the PDF. Paragraph 54, the court rejects that submission, saying it's unrealistic for the court to have such a system for moving up, where there's been no notification to the court of the particular urgency of the matter in question. And reading on from 54, my Lords, again, I don't propose to read it, but 55 and 56 of Telford again address what the claimant could do about it. In 56, second sentence, it's open to the claimant in circumstances such as those here to flag the urgency application when the claim form was filed and to chase the court for the claim form to be issued. Mr. Leader says there's no obligation on the claimant to do that. That is right, but it does mean that a claimant who chooses not to take such steps is failing to do so deliberately, having already chosen to file the claim late, although we'll also be aware I don't take the point that the claim was filed late.
No. Well, you didn't read the next sentence. Do you submit that the claimant in the present case, i.e. the respondent, here did in fact deliberately leave matters in the hands of the court in circumstances where it's open to the claimant to seek to prevent delay or to encourage expedition, etc.?
Yes, my Lord. We'll look at what was done in the interim period. The point that I don't pursue on behalf of the Secretary of State is that the filing was late. This isn't a case, my Lord, where a claim form was filed in the last few hours and it properly sits with the claimant in those circumstances. They do not attract sympathy because they've left things till the very last minute. This claimant didn't do that. The Secretary's case is simply they didn't take all reasonable steps because there were things that could have been done, my Lord.
A question that lurks, I think, in these submissions is, in the present circumstances, at least, if not more generally, but in the present circumstances at least, what was the claimant entitled to expect, if anything, of the court office, vis-a-vis the taking of all reasonable steps on it, or by it, that is, or by him. Could be a spectrum, I suppose, in which nothing should be assumed by way of competence in the court office, all the way to the other end of the spectrum where one places total reliance on the court office to do everything and do it right in every case. That is a question, I think, that lurks here.
I think that's true, my Lord. My Lord, I'll wait I'll wait 30 seconds if I may.
Deal with that,
Spillage, I'm so sorry.
with that small environmental issue here. I wasn't looking.
It's not causing any other problems. Honestly, it's fine.
Yes, sorry.
My Lords, I'm very grateful. My Lords, two points. One is the paragraph that I took my Lords to in Telford, paragraph 56.
56.
Makes the point, my Lord, that that chasing an application with the court is not something that a defendant can do. A defendant has no nexus at that stage. So if one assumes that someone has to do something, it's plainly it falls on the claimant to chase the claimant's application. And my Lord, if one then remains in Telford and moves on to paragraph 61 and page 101, my Lord, there the court is dealing with all reasonable steps. And third sentence, my Lord, in the middle of the paragraph, there's no evidence and it's not suggested that anything was done at the time of filing to alert the court to the need for urgent action. There's nothing by way of saying to the court, we're right up against the limit, please put it to top of file, please issue it urgently. And paragraph 62, my Lord, the reality is that here those acting for the claimant did not appreciate the gravity of the position or the rigour of the time limit. As a consequence, they did not take steps to address the need for the claim form to be issued with sufficient urgency. So, well, the short answer is, to my Lord's question directly, is that there are two positions. One is that it is the responsibility of the claimant to chase and let the court know that this is urgent, we need a sealed claim form because we need to serve it. That ties in with Telford and it ties in with the learned judge in this appeal's decision in Merrill's. The second is, if having taken all of those steps, the court still fails to issue the claim form, that then goes into the mix, my Lords, when one's looking at an extension of time under 7.63, CPR 7.63, my Lords. So my submission is that the judge below in this appeal should have adopted the same approach to the court's delays as Her Ladyship did in her judgment in Merrill's, and found that the court officer's lack of promptitude in issuing was an issue that the respondent was required to take all reasonable steps to address. And in respect of all reasonable steps, and I'm placing deliberate emphasis on the words all, my Lord, the respondent says that all reasonable steps were taken as he's bound to do. An email was sent on the 2nd of May 2023 marked high importance. My submission is that those two words are doing a lot of heavy lifting. If one looks at the email itself, which is on page 99 of the core bundle, my Lords.
Yeah.
The first point, my Lords, to make is that the high importance element is simply the Microsoft email marker that one clicks a button to say, is it high importance, low priority, whatever, and it automatically applies that flag to one's email. My Lords will see at the top of the email on page 99, underneath the header block with from and sent and to objectives, importance high. That's what my learned friends case says is sufficient to be all reasonable steps. If my lords then read what the email actually says, on the 2nd of May, so 2 days before the statutory deadline, solicitors there are simply asking for the court to acknowledge receipt of the claim. Nothing which indicates the urgency in my respectful submission, my lord. And
Yes, it incorporates the previous email, of course. So you need to read the two together, obviously.
the 18th of April email on 98, my lord.
Well, it expressly refers to that email, copy attached.
Yes, my lord.
So
That is back one page, my lord, on page 98.
Yeah. So the recipient would be expected to read both emails, including the earlier email, to remind themselves of what
That's
that
correct.
meant.
That's correct, my lord. And my lords, I won't take you back to it, but my lords, I took you to paragraph 29 of Merrill's, where the learned judge in another case accepted the point that it had been advisable to tell the court in terms the deadline issue and the statutory deadline issue. There's nothing in my respectful submission in 98 or 99 in those two emails, my lord, which makes that clear, although I accept, of course, that both emails have the high importance marker on them.
So you are submitting, in effect then, or are submitting, that in the present circumstances at least, it was incumbent on the claimant, if to satisfy the all reasonable steps test, to spell out to the court office what the time limit actually was.
That's correct, my lord.
That's the submission.
That's correct.
Is that right? I don't want to put words into your mouth.
No.
That is your
that would go some way to meeting the test, my lord. But also there is a point about the test in the CPR says all reasonable steps, my lord.
Yes.
And the authorities have taken, my lord, to says one can turn up at the court office in person, one can send further emails. If there had been...
Right. Well, you are submitting to us that to satisfy that test, all reasonable steps, that is, in the present case, it was necessary for the claimant to spell out in terms to the court office, at least on the 2nd of May, what the time limit actually was.
Yes.
You are submitting that?
At least, my lord.
Right.
But what I'm also submitting, my lord, is there were other things that could and perhaps should have been done in terms of there could have been more emails, my lord, there could have been more telephone calls before the expiry of the statutory deadline. But what I'm saying is, had the email on the 2nd of May spelt the position out in explicit terms, then that might be an issue which in the discretionary exercise that the court needs to undertake would weigh in favour of the claimant, because the court would be on notice in that sense.
Well, then I'm tempted to ask you next. In the present case and in the present circumstances, what else was it necessary as a minimum for the claimant to say or do which it did not say or do? You've acknowledged the point about spelling out the time limit. What else was an essential and indispensable ingredient in its behaviour?
My lord, it would be sufficient actions to demonstrate to the court that all reasonable steps had been taken. So,
but that may be just circular, isn't it? I mean, what I'm asking is what were the all reasonable steps, actually?
My lord, what one could look forward at what the claimant did after the expiry of the deadline in terms of calling the court, explaining to the court the urgency. One reasonable step that potentially could have been taken, my lord, was to make an application for an extension of time at or before the expiry date to let the court, put the court on notice that there was a serious issue. But that presupposes that one has notified the court of the issue, my lord. I don't think that I can say that there are X steps that one should take
No,
to show
but,
that one has
well,
taken all reasonable steps. My lord.
Well, we understand that response, but at the same time, you understand why we are asking the question we do.
Of course, my lord.
Yeah.
Of course.
And you do submit also, I think, that steps taken after the 4th of May were actually not germane to the question of all reasonable steps.
My lord, it's the next point that I intend to go on to.
So the only relevance of an extension of time application would have been that if it had fallen within the 6-week period.
That's correct, my lord. But one can make an extension of time
Of course,
application
yeah.
before the expiry of on the 2nd of May.
But I mean, an application made on the 5th of May would not go to all reasonable steps up to the 4th of May, which was the relevant period.
That's correct, my lord. That has to be my submission.
Mr. Fry, can you help me with this? The emails are to the Administrative Court Office in Manchester, so we were dealing with not the general civil office, as it were, but a specific bit of the court that was dealing with admin court matters. Is it relevant to ask? I was going to ask you the question, but I should preface it with: is it relevant to ask the question? Because you might say it's not, which would be a legitimate response. To what extent these kind of claim forms or these kind of cases, what sort of sense of how common are they from the point of view of an admin court? I mean, at least it struck me that if, for example, this was the only kind of claim form the admin courts in Manchester ever had to deal with, and solicitors might be expected to know that, one might think it was reasonable to expect them to know what the rules were and how urgently they needed to be. On the other hand, if this was a once in a blue moon kind of application, then the reverse might be true, or it may be somewhere in the middle. But do you say that's a relevant consideration? And if it is, what's the answer?
Well, respectfully, I'm not sure that it is relevant in the context of the submissions I'm making, but it perhaps is again relevant in terms of what steps might be taken in terms of notifying the court. My learned friend took the point, I think it is in the judgment, my learned friend will correct me if I am wrong, that actually had this claimant issued in London, it's likely that none of these issues would have arisen on the basis that Manchester aren't used to dealing with these kind of claims.
Yes.
But I'm not taking that point against my learned friend in the sense that if one issues in any court office, one ought to be able to expect that the court office would be equipped to handle administrative court claims. So I'm not sure I can take that any further, and I can't give evidence on behalf of the court office in Manchester, who, my lords, as my learned friend knows and is accepted in the judgment, I accept that it's pretty unforgivable to take so long to issue a claim form, but my submission is that that's equally not the point, that's not the fault of the defendant in this claim, who is entitled to the limitation defence that the statute provides, that the rules provide for.
Okay, thank you.
One aspect of the background that we get from the emails is that certainly at one point Manchester was checking with Leeds about how to do this, because there seemed to be some confusion because there was a section 289 as well as a 288. And there are references in the telephone notes to that, and checking with a lawyer and checking with the administrative court in Leeds Administrative Court, 30th of May. So that might suggest that those actually dealing with it weren't over familiar with the process.
I think that's right, my lord. I can't escape that point, and I'm not seeking to defend the actions of of the court office. It is, as my lords will appreciate from the first instance authority, there are times when the rules operate in a way that seems quite arbitrary and unfair against people, but the rules are there for a purpose, is my submission, my lords.
Yeah.
My lords, moving on, the next point is the point about chasing after the expiry of the time limit. My learned friend says that the court's entitled to look at all the actions taken when considering reasonable steps, sort of a global approach to actions taken. My lords, that's the new authority that my learned friend hasn't seen yet, which I handed up this morning. It's a very neat and short point, so I can ask my lords simply to take up the Carnegie case. And my lords, it's paragraph 36 of that case. fourth sentence, my lord, and I'll read it. However, much more fundamental in the judge's error in taking into account the steps. Sorry, much more fundamental is the judge's error in taking into account the steps taken to effect service after the 4-month period had elapsed. Subparagraph B requires the judge to consider whether all reasonable steps were taken to serve the defendant during the 4-month period allowed. Attempts made after that time are irrelevant. In my view, the judge erred in taking the latter effects into account. Well, as I simply say, that's direct Court of Appeal authority on the point. And again, I need to make further points on that, my lord. That is respectfully correct, as actions after expiry cannot possibly indicate that reasonable steps were taken before expiry, for the simple reason that CPR 7.5 provides the deadline in the introductory sentence of CPR 6. And 3 deals with the order to extend time for compliance after the end of the period. Within the deadline, the claimant's got to complete the relevant steps required within that deadline. So my submission is that it was irrational in these circumstances for the judge to have taken into account post-expiry steps when determining whether or not reasonable steps had been taken.
Well, does it need to have been irrational? Could it be
Simply
wrong in principle?
Wrong in principle, then, my lord, rather than irrationality. It's a lower bar, so I will go with that if I may, my lord.
Yes.
And lastly, it's a short point in respect to reasonable steps, my lord, but it is relevant. As my lords will have realised from the chronology, the claim form was sealed and provided to the claimant on the 11th of July, and the respondent attempted service on the 11th of July, but failed. So my submission is that on any view at that stage, service of the claim form was wildly out of time, and an error in service then means that, again, not all reasonable steps could have been taken. The reasonable step would have been to have served it correctly on the 11th of July. So, my lords, there's then a further 1-day delay.
But that's not on any critical path on your case.
No, my lord.
Because you say by the 11th of July they'd already failed to take all reasonable steps.
Yes, my lord.
In fact, you say they'd failed to take all reasonable steps by the 4th of May.
No, that's correct.
So
That's
we're
correct.
a long way off the critical path because it was an error on the 11th of July.
But if my lords are against me on all of my previous submissions, it's my last gasp,
Your last
my lord,
gasp.
to simply say that there was a further delay right at the end of this process, my lord, which cannot, in my respect, submission be an indication of reasonable steps.
Mr. Wright, sorry to go back. We're just thinking about the application of 7.6 and the authority, the Carnegie authority. The territory we're in is we're applying 7.6 by analogy rather than applying 7.6.
Yes, my lord.
In the context of what behaviour is relevant, 7.6 is predicated on the fact that the claim form has been issued. The deadline only exists because the claim form has been issued. I think that's right. Because the deadline 7.6 is talking about is the deadline which runs from the issue of the claim form. Well, 7.6 isn't directly talking about a deadline, but the deadline it's concerned with is one that
understand the
arises
point,
from
my
the
lord.
issue. So it's not quite the same when you're applying it by analogy, is it? Or is it?
If I may just take 30 seconds to think about that. My lord raises a... Well, it's a point that one needs to go back to 7.5. That deals with service of the claim form. Where I'm struggling, my lord, is where it requires issue. Obviously, there is a logical nexus between the issue of the sealed claim form and the ability to serve. One has...
Yes. Not sure it's in 7.5. I'm pretty sure, off the top of my head, I'm sorry to ask you the question in this way because I didn't sort of get the rules out ready to arm you with the with the rules.
My lord,
I'm pretty sure that what is supposed to be served is an issued claim form.
Is an issue claim form, my lord. Quite right.
And the time limit for service runs from the date of issue. The 4 months normally in civil justice, normally, I think.
Well, my lord, that's where...
And of course, it doesn't. It's not the same in the context that we're talking. I mean,
That's the point. Why in a section 288, as my lord will have seen from all the authorities, because of the application, someone trying to help me out with, because of the way that the rules are drafted. If my lord, I won't take my lord to it, for Farnham Town Council in those cases, because one here has service, filing and service within that 6-week window. My lord ends up in a position where you can have your claim form issued on the very last day and be unable to serve it. One is still out of
the point of my question, I know you know, but the point of my question was about when you were applying 7.6 by analogy in this circumstance, whether something like Carnegie is necessarily the same or not. That was the point of my mind. I think you understand that.
I absolutely understand the question, my lord. And my submission on that would be, my lord, that if one... The difficulty is how far one goes when one's applying something by analogy. I think in reality that means that 7.6 applies. I can't think how one would distinguish the relevant tests simply because it was by analogy. The point, and if one reads good law and the first instant cases that I referred my lord to, is that 7.6 applied in full force. It was a roundabout way of going through CPR 3 to get to the relevant tests in CPR 7.6. No one has said that those tests should be in any way attenuated because it's by analogy. So my simple submission is that 7.63 applies in full force, although I of course accept the thrust of my lord's point. The only submission I can make in that regard is what I've made, and the statutory scheme says you've got 6 weeks to do everything.
Because the bottom line difference is that the 4 months starts with the issue of the claim form, whereas the 6 weeks is nearly at an end in most cases, probably all cases, by the time the claim form is issued. So it's a completely different series of time pressures, if you like. But we are still looking at 7.6, as you say, by analogy, but we are still looking at 7.6. So it's a question of sort of translating one to the other.
That's correct, my lord. And as I said right at the start of my submissions, it does create arbitrary decision-making and on occasion an element of unfairness. But all of the first instance authorities that I refer my lord to rely on the position that that's what Parliament intended. It's set out in the authorities that the 6-week window is there for certainty in public decision-making in respect to planning. So that is the effect, but it is the effect that was intended, my lord.
Well, on a related point, can I just ask you this? And you might say this is a very unfair question, but I'm going to ask you anyway. Why are there all these cases suddenly on Section 288 time limits? I mean, as you say, there are half a dozen, and an area of jurisprudence that's not previously troubled the scorers over much. So why suddenly are there? I mean, I have what I think might be the answer, but I just wondered if you had an answer, or is it just one of those things?
My lord, I think the only thing I can say without giving evidence is that very often these cases are cyclical, and someone picks up a point in a certain case and runs with it, and other people build on on that point.
All right. Well, I get that. I just wondered if the change brought in by PD 54, which says that it's what matters is service, and that's a change. Because before, I think it was issue, but it's now service. So it's now a further step by a claimant. I wondered whether that change had this possibly unintended consequence.
Potentially, my lord, and I'm afraid the answer is that I don't know, so I don't want to...
I'm always interested to know why something suddenly become flavour of the month in terms of applications, but no, that's fine.
No, my lord, I'm afraid I can't assist as to the why.
No.
But as I say, over the course of the last year or so, I think at first instance, the position has largely become settled, and good law has run its course through into first instance, and there are a lot of useful judgments now which are consolidating matters, and this court might wish to say something about that to assist claimants and respondents. Well, I just want to, when we have 30 seconds, I just want to check that I've said everything I wanted to say on the reasonable steps point, because I then want to just turn to address promptness or promptitude.
These are the stylistic guidance I need.
My lords, I think I've taken you to all the relevant passages that I wanted to draw to the court's attention, but they are in my skeleton argument if my lords need a note. Turning then, my lord, to the second part of the relevant test in CPR 763, again accepting, my lord, that it's applied by analogy, but saying it says has full force. That's whether the claimants acted promptly in making the application. And I wasn't able to find any authority from this court on the meaning of promptness. Certainly at first instance, it's always been the case that promptness was a discretionary matter for a judge on the facts. But
there will be some authority in the sphere of claims for judicial review. Is that transferable?
My lord, there is in terms of the exercise of the discretion, but I'm more focused on the meaning of promptness, or when the promptness starts to be more explicit in these submissions.
If this was a criminal trial and somebody raised that, I'd say promptness is a perfectly normal English word to be given a perfectly normal meaning.
It is, my lord.
Yes. But to get to the substance of it as well, is it common ground between the parties here that promptness has an objective aspect as well as, and perhaps predominantly an objective aspect, as well as any subjective aspect?
That's correct, my lord. And the subjective aspect is I think, accepted between the parties, a matter of discretion for the judge. Yeah. The point that I mean to tease out is what promptness means in the context of 7.6.3. Because my lords will appreciate that the judge doesn't say much on promptness, except for she finds that it was prompt because it was perfectly fine to wait.
Well, to be fair, she doesn't say anything about promptness.
I mean, I will double check. I'm not
paragraphs. It's paragraphs 12, 13, and 14. She extends time up to the last date that it was served. But if there's an analysis of whether the application to extend time was made promptly, I've missed it.
Well, Lord, quite right. It's 14 that I had highlighted. The issue knows can answer. Yes, and the same. My lord, what one can understand from the reasoning, what the judge was saying, that essentially it was prompt because the focus was on obtaining the sealed form and the assurance was given.
Yeah.
So, in fairness to the judge, I certainly understood that as her addressing, her ladyship addressing promptness. Just check, my lord, if there's anything else that I need to say. But, well, the issue that really on canvas with the court in respect to promptness is that when does time run in respect of being prompt? And my submission, my lords, is if one reads CPR 7.63 C in context, one reads it in the context of 7.6 and particularly the opening sentence of 7.63, if the claimant applies for an order to extend time for compliance after the end of the period specified by Rule 7, the court may make such an order only if ... the claimant has acted promptly in making the application. So my primary submission is that the time that the court is considering must be the time that time expired in terms of promptness, because that is the plain reading of those relevant provisions. Because one can only understand 763C in the context in which it is written, and that includes the introductory sentence. So where one is considering how prompt an application is, my submission is one needs to consider what one is being prompt from, and that, respectfully, must be the decision that is out of time. And in the application to this case, obviously, my lords, is then one is considering promptness from May rather than July, when the realisation struck that an application needed to be made.
But an application needed to be made from the 4th of May.
From the 4th of May, that's correct.
Because that's when time expired.
That's correct.
So, I mean, the argument may be, well, we didn't have a sealed claim form until, whenever it is, the 11th of July. But an application was always going to be necessary from the 4th of May onwards.
That's correct. That's my point. When one considers then whether or not it's prompt to make it in July, my simple submission is it can't be prompt because the need for that application arose on the 4th of May. Apologies, on the 5th of May because it expired on midnight on the 4th.
So the time within which one considers whether or not the promptness test was satisfied is the time following the deadline for issuing and service of the claim.
That's my submission.
Yes. Otherwise it would be to add an additional test before that point. In other words, all reasonable steps and also separately, promptly. Is that how you reason it?
That's exactly my point. My secondary submission, if the court wasn't with me on that, is if one says that it doesn't arise from the time of the expiry of the deadline, it surely must start from the time when one was put on notice of the fact that one needed to make an application. And again, in this case, I say that was on the 4th of July when the Secretary of State wrote to the claimant and said, "You're out of time." At that point, the penny should have dropped and an application should have been made. But that's a secondary submission. My primary submission, my lords, is that it has to be from the time of the expiry of the deadline. That reasoning doesn't, as my lords noted, come into the judge below's decision. My lords, I apologise, it didn't have the reference, but it was a point that Mrs. Justice Lang made in Home Farm. If I may have 2 seconds, I'll see if I can turn it up. Yes, my lord, it's on Authorities Bundle 4, page 85, Mrs. Justice Lang over to comments because she decided the case on another point. But at paragraph 56, the judge addresses whether or not the claimant acted promptly in making the application. And she simply says the claimant should have made the application as soon as possible on or after the 4th of November 2022, which was the deadline provided for in the rules. So, well, what we end up with is an application to extend time made on the 13th of July 2023, which was 70 days after the expiry of time for the service of the claim form, and a week after the Secretary of State told the respondent that the claim form would be out of time. Again, my lords, that is a different approach, in my respectful submission, to the approach the learned judge took in Merrill's. I don't think the court needs to turn it up, but the reference is paragraph 35, 36 and 37, Authorities Bundle, page 68.
I'm so sorry, I missed the paragraphs.
35, 36 and 37 of Merrill's on Authorities Bundle 68.
Yeah.
And the judge there simply says, however, the claimant's advisors would have realised on the 15th of June 2023 that the deadline for service had been missed and that an application for extension of time would be necessary. Those discussions should have commenced much sooner. Although I'm bound to draw the court's attention in the next paragraph, her ladyship does say that there could have been some delay until a later date, but the reasons I've set out, I think the judge was wrong in that regard, and it should have been from the time of the expiry, my lords. I think, my lords, have my submissions on property generally. The respondent should have known on the 4th of May that an application was required. The respondent was warned on the 4th of July, and in those circumstances an application on the 13th of July cannot be viewed as prompt. See Telford at paragraph 59 and Home Farm, which I took my lords to at 56. And as I said before, my lords, where Parliament has provided for a 42-day window, an extension of time 70 days after the expiry of that window is simply not prompt. I think it's agreed between the parties, but in case I need to make the point, my lord, the point is that there is prejudice to the Secretary of State in these circumstances because one is 70 days after the expiry of time, and there is a palpable prejudice as the claim was served so late on the Secretary of State.
This is the limitation defence point.
It's where the prejudice rises, my lord. And my lord, I take my lord to Telford, bundle 5. I'll find the page. It's paragraph 55 of Telford, my lord. I'll just get it, my lords. My lords, don't need to turn it up. And essentially, all it says is that the loss of limitation defence was palpable prejudice.
I think that expression derives from a judgment of Lord Justice Underhill, doesn't it? Is that right?
That's probably right, my lord. It's followed through, and it appears in, I think, every first instance judgment that the court has in front of it now, that there is prejudice.
Well, I'm sure it's my fault, but I don't follow that in relation. What's that got to do with promptitude?
My lord, it's dealing with it's not dealing with promptitude, but it's an explanation for why promptness is important, in the sense that if there is a limitation defence, any delay over...
But there would always be if you're making an application to extend time after the period's expired under 763,
Yes.
there would always be a limitation defence.
Yes, there would. And one of the things...
So it can't be a trump card.
My Lord,
Otherwise, you'd never, no extension would ever be, sorry, no application would ever be successful.
My Lord's quite correct. It isn't a trump card at all. It's a reason and in the balance as opposed to an explanation.
Okay, and the second point here that arises on the facts here is playing devil's advocate and putting it in tendentious terms. How could we possibly be swayed by the fact that a defence had accrued to the Secretary of State for one department because of the ranking competence of another government department? Put it this way, that doesn't feel right to me.
My Lord, I understand.
You have a defence because another Department of State mucked up the service of the claim form. Not the service, the issue of the sealed claim form.
My Lord, all I can
I mean, that's just, when I was looking at it, I just thought, hang on a minute. I didn't find that amongst your more attractive submissions, Mr. Pry. I hope that puts it fairly.
My Lord, I absolutely understand the point. My Lord, the point is that as I've accepted, the delays are unjustifiable. But, my Lord, the critical period which I'm urging the court to look at is the period between the 18th of April and the 4th of May and what occurred there. And in that regard, one has to go into the CPR 7.63.
Oh, no, that I get.
My Lord,
I don't have a difficulty with the all reasonable steps because that's a burden. I understand your submissions on that. That's a burden on the claimant, respondent in the appeal. I understand that. It's just the promptitude reflecting on the limitation defence point. There are plenty of points, and you've made them, about promptitude in comparing the 42 days with the 70 and so on. But as I say, as a general principle, I don't think that the existence of a limitation defence can be a trump card, and you accept that. And here, it's very much the three of diamonds, in my view.
My Lord, I can't resist that, my Lord. You my Lord knows well I can't, in that my Lord understands, of course, that government departments are different, although the Secretary is indivisible.
Of course, I understand.
My Lord is correct. There is
you could present it as that, is all I'm saying.
My Lord, that is absolutely understood. There is frankly no response that I can give to that point presented, as my Lord has, albeit, as I say, government departments are separate, my Lord. This isn't a case where the defendant being the Secretary of State for levelling up communities and housing, has actively, if my Lord takes that analogy further, one gets into, has service been obstructed and so on and so forth by the particular defendant. My submission is we're nowhere near that position here. This is not a case where this Secretary of State has done something to prevent service upon him, as I think he was at the relevant time.
Yeah.
My Lord, I think those are my submissions. I think those are my submissions. Those are my submissions, my Lord, unless I can assist any further. I'm very grateful.
There's just one outstanding request, which is the claim form as originally issued.
My Lord, I will look for it now, and if I turn my back at a convenient moment, I'll ask those sitting behind me. I'm grateful, my Lord.
Thank you very much. Yes, Mr. Red.
Lords. I'm going to structure my submissions in the context of the principles, which I'll be very brief on because I don't think there's any dispute between the parties on those. Then just a quick run over the facts of the case where I see them to be important, but also as the learned judge, her ladyship, identified them. And in that context, I just want to draw your lordship's attention to some of the important facts of the authorities that are in the bundle, in terms of the chronology of those documents, because they do, the examination of that is important in putting into context the chronology in this particular case, and the behaviour of the the respondents' representatives in this case, and then I'll look very briefly at the two grounds of appeal, which will largely have already been covered in what I've done.
Understood.
So, we are looking at, I think it's by agreement really, we are looking at 7.6 by analogy, and the approach, largely the approach set out in good law. Obviously there's elements of good law which are not particularly applicable to this matter. So I don't need to trouble your lordships with that anymore, because my lady friends set that out, and they set out in the skeletons. I don't think there's any dispute between us. In terms of the facts of this case, this is not a case where the respondent has waited until the last minute to file the claim. And that's important when one looks at how the courts have considered recently a tranche of similar matters. The respondent did so, it was 25 days into the 42-day period. And that, in my submission, is important. They acted expeditiously and afforded the court, unlike in all of the other authorities, afforded the court adequate time to issue the sealed claim documents. This isn't a case where the respondent didn't notify the court office of either the nature of the claim or that it was important. Your lordships have been taken to the email that was sent with the filing, and it was marked high importance. And on the email Outlook system, a high importance email, it's not just words, it comes up with a big red exclamation mark, so it stands out and you can see it. But also, your lordships will see that the actual header for the email it said, the title of the case, Appeal under Section 289 and Application under Section 288 of the Town and Country Planning Act, in bold, underlined. So as well as identifying that this was a case of high importance, the email itself specifies the nature of the case. And an administrative court office should be aware, in my submission, that automatically engages accelerated time scales over and above that of a normal judicial review. And then further down in the email, after there's 5 bullet points, I'm looking at page 96 in my bundle, it says the appeal and application are inextricably linked as they both relate to the same planning decision. So the recipient of this email, 25 days into the 42-day period, was made very well aware that this was a planning matter and that strict time frames are engaged. And this is not a case where the respondent solicitor didn't chase the court, just left the court to it, because there was a chasing email sent on the 2nd of May before the deadline. That email also was sent with the high importance tag. And that email, as your lordships have already mentioned, attached a copy of the previous filing email. In my submission, the respondents' solicitors have acted reasonably in that context and expeditiously, as your lordships will see when we come to look briefly at the other cases in the authority bundle. And this isn't a case where the court office have issued in time, but the respondent has, for some reason, failed to serve. It was issued on the 11th of July, and that's 9 weeks and 5 days after the deadline. Your lordships will have seen that there's something of the order of 13 chasing phone calls and emails, and no explanation was ever offered as to why why it took so long. And your lordship would have seen that during the process, the court, in error, issued a sealed application notice for the Section 288 application that was made at the same time. So it just got it completely wrong throughout the process. Now, your lordship's asked the question of my lady friend, what expectation can a claimant, or indeed an applicant under 289, have of the court? Well, in my submission, somebody acting expeditiously, as in the respondent's solicitors in this case, can expect the court to act expeditiously and reasonably. But it's clear from the documents, the email trail and the telephone calls exhibited to Mr. Beasley's second witness statement, that the court office just did not grapple with the claim or the application. For whatever reason, it just, they just didn't acknowledge or understand the urgency behind it, despite having been told, and despite having been told that this was a planning claim. Now, your lordships asked about what is the experience of the Manchester Court. Well, your lordships will be aware that the regionalisation of the administrative court started in around 2009, or in 2009. And the communication that those instructing me had with the court was with the clerk of the administrative court. So this was a specialist clerk in a specialist court tasked with dealing in part with planning claims, planning applications. They're used to dealing with these claims in my submission. I'm in chambers in Manchester, this is the Manchester court. And I'm not going to give evidence, but your lordships can see from the two of the cases in the bundle, the Merrill's case at tab 3, that was a Manchester admin court case where the relative date, the important dates were around June 2023, so we're dealing with the same sort of period. And the Halton case, Halton Borough Council case, tab 6, that also was a Manchester administrative court case, planning case, and that was February 2023. So the administrative court office in Manchester is used to dealing with these claims, knows what to do with them, and simply, in this matter, just didn't. And there is adequate, such claims have been taking part in Manchester, occurring in Manchester and Leeds and Birmingham now, and Cardiff, for some years. So then, if one looks at the detail of the factual detail of the cases in the bundle, I'll take that they can be split into two different headers, if you like. One's where the claim was filed in time and the court issued in time, but the claimant failed to serve. And the second tranche, if you like, is those that were filed in time but issued after expiry. And there was a common theme to all of them. In the Farnham Town Council case, I'm not necessarily going to take your lordships to these paragraphs because it's just factual dates, unless your lordships want me to. I can give you the reference.
No, that's fine. Thank you.
So those are your two categories.
They're the two categories.
Right, and are you're dealing first with Farnham?
In the first category, which filed and issued in time.
Okay, that's for my pedestrian note. That's what I was asking for.
Yeah.
So the first heading is claims filed in time, issued in time, but a failure to serve.
Yeah.
And you say Farnham, and you were going to give us the paragraphs.
Farnham paragraphs. It's tab 1. It's paragraphs 15 to 16.
I think tabs are a bit of a luxury that certainly for my bundle
Right.
I don't have. So
Okay.
just do the paragraph number.
Paragraphs 15 to 16. I only got the paginated bundle this morning, so I very rapidly tried to write down the
Paragraphs are fine.
Okay, 15 to 16. Farnham Town Council claims filed on the deadline date.
Yeah.
It was issued on time, failed to serve. The point I'm making there is filed on the deadline date. Halton Borough Council case, it's paragraphs 25 to 27, and 28 and 31. Again, filed a day before the deadline, 1 day before the deadline. Court issued in time, served out of time. And I've already referenced, Your Lordships, the fact that Halton Borough Council case was a Manchester Administrative Court case.
And that's Judge Stephen Davis.
Yes, I think so, yeah. Yes. The two cases under the first column. The second column, the filed in time issued after expiry. Aurora Properties.
Sorry, filed in time but issued after
Expiry.
Yeah, and that's Aurora.
Aurora Properties. And that was filed on the deadline day. Paragraph 32. The court issued it a day later, and it was then served 7 days later. And the application to extend time was made nearly 3 months after service. That's paragraph 53.
Sorry, how many weeks?
It was nearly 3 months.
Nearly 3 months.
Yeah. After service.
Yeah.
And then we turn to the Home Farm Land Limited. The claimant attempted to file on the deadline day at 15:45 hours. It's paragraph 15. He amended the claim form the day after. There was defects in the identity of the defendants, interested parties. So he amended the claim form the day after. That's paragraph 18. The claim form was issued that day, so 1 day late. But it was then served 21 days later. Paragraph 54. And the application to extend was made 1 month after the issue of the sealed claim form. It's paragraph 56. And in the Merrills case, the claimant filed the claim 1 day before the deadline date, 14:58 hours in the afternoon, paragraphs 2 and 7. The court issued the claim 6 days after the deadline, and it was served on the same day. It's paragraph 10. And the application to extend time was made 14 days after service. That's paragraph 11. As I said, that was another Manchester Administrative Court case. The Telford and Wrekin Council case. This was filed 5 days before the deadline. But in those 5 days, 2 of the days were a weekend, and 1 was the Coronation Bank holiday when the court office was closed. That's paragraphs 5 to 7. The sealed claim form was issued 6 days after the deadline, paragraph 9. It was served 3 days later. That's paragraph 11. and the application to extend time was made a further 10 weeks later. That's paragraph 14. So in all of these matters that have been dealt with at first instance, matters relating to delay in issuing or serving, common theme, clear common theme, is that the claimants in every one of those cases left it to the last minute to seek to commence their proceedings, their challenge. That is not the case here. If I could ask your lordships to turn up the Merrill's authority, specifically paragraph 33. I have it at page 67, I think.
$33.
Yes, 33.
Yeah, yeah.
The court says the possible difficulties of leaving the issue of a sealed claim form until 1 or 2 days, as highlighted in the recent Halton Borough Council decision. It's on Judge Stephen Davis observed that such a strategy constituted an unnecessary risk, given that the claimant would need the cooperation of the court to obtain a sealed copy of the claim form for service. That is not a tactic or a risk that the claimant in this matter sought to take. He acted expeditiously within that 6-week period to commence proceedings pretty much 2/3 of the way through. Now, in that Merrill's case, the judge also commented that if one is to take that risk, it's at paragraph 34. She says, in these circumstances, I conclude that the claimants failed to take all reasonable steps open to it to effect service of a sealed claim form within the statutory period. Given the impending deadline, the claimant's representative did not avail itself of the opportunity to attend in person, essentially pitching up at the court office with a pile of documents and asking them to be sealed and issued, which one might take that approach in a last minute approach. It isn't something in my submission, a criticism that can be levelled at this claimant, the respondent in this case, because there was really no need for a respondent essentially 4 weeks into the 6-week period to attend the court in person, to seek to have the court, if it can, issue the proceedings there and then. So when the judge there is talking about attending in person, it's attending in the context of last-minute claims, and really common sense tells you one should attend the court, do whatever one can to get it issued straight away and served that day. In the home farm land case, if I could ask you to turn that up, it's paragraph 53 at page 84. Applying these principles, the first question is whether or not the claimant took all reasonable steps to effect valid service in time but was unable to do so. Except the Secretary of State's submissions on this issue, Mr. Walton left it far too late to find out how to file the claim properly, complete his preparation of the claim, and then to file it at the court. He did not successfully pursue the options of filing by email or via the DUC. The late filing led to late service. And that, in essence, is the crux behind all of the authorities in the bundle. Late filing has ultimately led, for one reason or another, to late service. This is not a case where late filing has led to late service. just one further authority, one further reference in the authorities that I'd like your lordships to take into account. It's in the Telford and Wrekin judgment. It's paragraph 57.
Can you give us a page number?
I think page number is page 100.
Thank you. Yep.
Mr. Justice Eyre there says, a claimant which has filed a claim form in good time and/or has acted energetically to alert the court to the urgency of the matter and to the need for urgent treatment of the application is very likely to have been found to have taken all reasonable steps, certainly in the former instance. Well, the former instance applies here. It's on all fours, more than adequate time in terms of the filing, and it was noted the email with the filing made it clear what it was that was being sought, and it should have made it clear to an experienced administrative court office. Follow-up email prior to the deadline did exactly the same thing.
Why not just spell out the date?
I accept that is a criticism.
Because, Mr. Justice Eyre in Telford, when he talks about energetically chasing, he gives some detail about that. And one of the things is making it clear that this has to be done by then because that's the time limit.
Yes, and my solicitors did not do that. But the point what Mr. Justice Eyre says is that either file it in good time and/or energetically. So if one's going to do it late, energetically say, I've done this late for whatever reasons. There can be many reasons for that happening. For whatever reason, this is the time limit. But filing 2 weeks in advance of the deadline.
Do you say that is filing early, let's call it early, 2 weeks in advance, plenty of time? Do you say that is on its own sufficient?
In my submission, it should be, but bearing in mind there's a follow-up email as well prior to the deadline. I accept that those instructing me didn't say, in terms, this is the deadline, can you sort it out? But in my submission, it shouldn't really be incumbent upon claimant solicitors or claimants in general to be notifying the court on an application of the deadline. An experienced court office should take that on board.
Well, you say it should not be for the claimant, and up to a point I understand that, but it is for the claimant to take all reasonable steps. So these things ultimately are for the claimant, aren't they?
But it's all reasonable steps, not necessarily all steps. And in my substance, when the claim is filed, will have an impact on what can be considered to be reasonable. So if a claim is filed late, as in on the day or 2 days before, it is absolutely reasonable and arguably necessary for a claimant to make the court completely aware that the deadline is imminent and this needs to be dealt with. And actually the way to do that is to attend the court office yourself with the documents. And that's part of it.
If it's open, if you're lucky enough to find a court office that's manned, that's not, open between 2 and 2:30 alternate Wednesdays, not twice, and ask for Rita.
There are some issues with that I'm familiar with. But
since I'm not the Deputy Head of Civil Justice now, I can leave all questions of access to court offices to my Lord.
It can be taxing. One has some experience of trying to make applications for urgent injunctions in the regional courts, which can be quite difficult to get attention from the court office. But one should at least try if one has left the application so late.
So, Mr. Roy, can I just check your submission just on, you were showing us Mr. Justice Eyre's judgment in Telford at 57. I think, am I right that the point you're making there is that what the judge is saying is, in that reference to the certainly in the former instance, his judgment is, and I'm paraphrasing it in a slightly different way from what's written, but his judgment is that certainly filing in good time will be found to have been taking reasonable steps.
Yes.
That's what this means if you pack it round a different way.
Yes.
The language. He says it's very likely that filing in good time on its own could be taken reasonable steps, and certainly the filing in good time he thinks is reasonable step. That's,
Yes.
that's what you. That's the point you're making. That's why you're showing it to us.
That's the reliance I place on it.
Yeah.
And when a claimant files, will have an influence on what one might consider to be reasonable steps. If one files early, one should be entitled to expect the court to act expeditiously and reasonably, which didn't happen in this case. If one files late, the burden on the claimant is raised. And in my submission, that's what Mr. Justice is saying there. Is if you put your claim in good time, then you've taken all reasonable steps to get it across the line. In this case, we didn't just do that. There was a chasing email.
Well, but isn't that the point? Because in this case, assume that's the starting point. In this case, by the 2nd of May, you knew that that hadn't happened. So by the 2nd of May, your solicitors were aware that this hadn't been the sit back and just allow nature to take its course. And so they knew there was a problem. And by then they were 2 days away from the expiry of the deadline. So then doesn't it come down to our view of whether the email of the 2nd of May constituted what Mr. Justice Eyre called energetic chasing?
Well, no, Your Lordship, because Justice Eyre is splitting that into two elements. It's filing in good time and/or acting energetically to alert. I accept that email of the 2nd of May is not as energetic as it could be.
But by the 2nd of, yes, no, but my point is, by the 2nd of May, it must have been apparent that the filing in good time hadn't achieved its objective.
Yes.
So that you were in the position, through no fault of your own, I don't suggest for a minute anything else, but by the 2nd of May, you were in the position as if you had left it late.
I accept that the email of the 2nd of May could have been drafted in different terms. But that email in its own right, in the way it has been drafted, and it did alert the court again to the nature of the claim. It was chasing it. It could have been drafted in a different way, but that shouldn't trump, in my submission, shouldn't trump the expeditious behaviour of the claimant in the first place. In the context that there is, in my submission, and the learned judge found it to be so, an expectation, a reasonable expectation, that the court will act properly, efficiently, and expeditiously. Yes, I accept that email of the 2nd of May could have been drafted in slightly different terms. But the fact there was an email, it was chasing something that was urgent, it was notified as being of high importance, as was the filing 2 weeks earlier. And taken in the round, taking the behaviour together and the emails together, in my submission that does constitute reasonable steps. Of course, in these circumstances, there's always other steps that could be taken. That's the nature of the game, if you like. But whether it's necessary or reasonable to have to take those steps in the context of the behaviour before, late filing requires different steps to prompt expeditious filing. And in my submission, the claimant's representatives, the respondent's representatives did behave reasonably in seeking to get that, to get the claim issued. The other, going back to the common feature, if you like, between all of the cases. The first feature was that they were all filed on or immediately before the deadline. The second feature is that the applications to extend time in all of the cases were excessively delayed in the context of delayed beyond the date of service. And all of these cases clearly are distinguishable. The facts are distinguishable from the manner in which the claimant, the original claimant in this matter, conducted himself through to the point of applying for extension of time.
If it was said to you, as we were turning this around, that on the 18th of April that email had been sent, but really nothing had happened. Suppose it was said against you, well, the solicitors acting for your client would then have been on notice that the court office was clearly dilatory, and that rendered it all the more acute, as it were, the need to do something different, as it were, to get some action, putting it bluntly. I mean, what would you say to that?
Well, the solicitors did. They sent a chasing email attaching the original email.
Yes, but they sent a chasing email, which was very much in simplified form in the same terms as the previous one. They didn't, as it were, go up a gear. Well,
they've gone up a gear in the sense that they're chasing, and that they're alerting the court, an experienced court office, to the specialist court office, to the fact that this claim was filed 2 weeks earlier, and we need some action. So they are stoking the fire. I accept, as I have done, that it could have been couched in slightly different terms that would made it abundantly aware of when the deadline was. But one would expect when a claim is filed with the court and is processed by the court, that because they have to check, the court office has to check that the right defendants or interested parties are included, and that's often why claim forms get knocked back, because there's been an error in it. The date within the claim form, the date of the decision that is being challenged is in there. So one would expect the court to as part of the process, to alert themselves and make themselves aware of when that deadline is.
But it wasn't quite as simple as that, was it, here? Because there were two different applications which actually had two different deadlines. And we understand all of your submissions about the Section 288 claim, but the Section 289 claim had a different and shorter period. And that, I think that was only 4 weeks.
Yes.
So that was only 2 or 3 days before. It was filed 2 or 3 days before that expired. So I mean, that was another factor in play, that there were two different applications which, as it happens, have two different deadlines.
Yes, yes, and the fact that the 289 and the 288 was alerted on the, well, we'll see an application form, but certainly alerted in the
it's on the heading of the cover,
header of
yes.
The email.
But the fact that, I mean, you said what the court office should have known. I mean, that's quite a specialist thing to know, that they have different time limits.
Well, it is, but it's a specialist court office. It's dealing with these cases. You can see at least 2 of the cases before your lordships are Manchester admin court cases. So this is not an alien matter that's before the office.
No, well, you made that.
Otherwise, there would be little point in regionalising the admin court. The whole point was to try and sort of take the pressure off the admin court in London by allowing claimants to commence actions in the regions, wherever that happened to be.
Could I just ask a question about, it's a question of fact, I think. If we look at the judgment, we see in, as it were, traditional form on the front sheet, in the High Court of Justice, King's Bench Division, Planning Court. This was a planning court matter. Does the ACO in Manchester have, as it were, a separate office or separate personnel dealing with planning court matters, or not? Do you know?
I'm afraid I don't know. It is the administrative court office.
Yeah.
That generally deals with.
The planning court operates, as you know, as a separate list within the administrative court.
I can't answer that question, I'm afraid. I don't know whether there is a separate office.
No, I mean, I don't know. That's what I'm asking. Thank
no,
you.
I'm sorry, Lordship, I can't answer.
No, that's helpful. Thank you.
So just in a pithy form, looking at the facts of this case, I do say that it was filed in good time. It was chased before and after the deadline, and I'll come to how that should be taken into consideration in due course. My instructing solicitors acted conscientiously throughout. And they served expeditiously. There was an error once they received the sealed claim form. They served it on the wrong email address with the Secretary of State, which does seem to be not uncommon, I'm afraid. When they were alerted to that, they served it on the correct Secretary of State email address. It was served on the second defendant, the local planning authority, on the day of issue, and in my submission, they did apply expeditiously to extend time. It's a bit of an odd one as to when one makes the application. You've got a court office who has received a claim which has not been issued. Therefore, there's no claim number. It just doesn't exist. It doesn't exist in the ether. Trying to make an application to extend time to serve proceedings that haven't yet commenced and don't exist, in my submission, is somewhat of an oddity. And really, when one considers the timing of the application here to extend time, which was the day after service on the Secretary of State, compared to the applications in the other judgments before you, which are weeks and in some cases months after service, by comparison, those instructing me did act expeditiously once they knew what extension of time they needed. The ladyship does.
I don't understand that. Surely, as from the 4th of May, they always needed to make an application. Yep. They didn't know for how long because they didn't have a claim form. But you don't specify. You simply say, I need an extension of time until I serve the claim form, which I don't currently have.
Because there are no proceedings. And
well, there's no claim form, but 763 envisages an application to extend time, I mean that's what you do.
Yes. The question is when is it necessary to make that application?
Or when is it prompt? Given that you know from the 4th of May that you need to make it.
Yeah, and the learned judge, she does deal with this in a slightly oblique way. But if I can ask your lordships to look at paragraph 13. That's page 45 of the bundle. It says, unlike in the good law case, the claimant did not choose to serve an unsealed claim form on the defendants. However, that is unsurprising considering the assurances given by the court that the matter was about to be dealt with. Likewise, issue of the application for extension of time came after the expiry of the deadline. But again, given the focus on obtaining a sealed form and the assurances given, this is unsurprising. So this isn't... clearly, I accept that the respondent could have made an application to extend time at any point. It seemed more sensible to make the application to extend time when the claim had been issued and was in existence and the extension of time was known. But one must also look in my submission at the context of why that application wasn't made earlier. And that context is the repeated contact with the court on up to 13 occasions, with the court saying, it's about to be issued, it's about to be issued.
But it wasn't. They said they'd deal with it after lunch. That was mid-May.
But that was persistent. That kept happening, and then they did issue the wrong form. Issued the application notice for the 289 instead of issue, which didn't need to be issued, didn't need to be sealed. That's not the process.
Yeah. So it's did not the time come when? I mean, it wasn't a binary choice. Chasing the court, of course, they needed to do that. But it wasn't a binary choice that you either do that or you issue an application for an extension.
No, I accept that. It's not a binary choice. But at some point, a decision has to be made by those involved in the litigation. And the process has been that we've chased the sealed claim form. it hasn't been issued, and we're going to keep chasing it. We keep being told it's about to be issued. It's going to be issued. There was even an email trying to list the case before issue of the.
I saw that because I mean that was, in a way, that was the office being helpful by offering a date, and I appreciate it was pointed out by your instructing solicitors, not unreasonably and slightly tartly, that there wasn't a claim form. So one understands that completely.
In that process, I accept that an application could have been made earlier, but in my submission, it was not unreasonable to make it when it was made, in the context of the persistent assurances.
I mean, do you accept that they're not mutually exclusive? You can make the application to extend at the same time as you continue to press or chase. And chasing what was, let's say, a catalogue of omissions rather than a catalogue of errors did not preclude the making of a timely application for an extension of time.
I have to accept that. Of course it didn't preclude it. It could have been made at any point. But I think a judgment was made that as a claim didn't exist, it was about to be issued. And it was felt that an application be made once the period of the extension that was required was known. That was not an unreasonable approach. And in fact, that's what happened. Once it was served, the extension application made the day after.
But the crucial question at that stage was not whether it was a reasonable or unreasonable approach. It was whether it was prompt. That was the critical question at that point. The question for the claimant and his solicitors at that stage is, am I being prompt?
Yes, and in my submission, the solicitors acted promptly after the service of the claim form, and the period of extension was known, as compared to the actions in the cases that I've drawn your attention to, where they didn't act promptly. There was weeks and months afterwards, after service, issue and service, that the applications were made. This was a day after service that the application to extend was made. Now, and in my submission, in that context, that is prompt, in the context of having received the sealed documents.
You say that promptness includes an element of reasonableness, in the sense that if you had a reasonable reason for what would otherwise be regarded as a delay, then that means you were still prompt. That's essentially your point.
Yes, and it has to be looked at in around in my submission. If this was a case where the claim form was filed, nothing was done, and it was just issued weeks later without explanation, and the solicitors in question were a bit tardy about making the application to extend time, well, there'll be a question about reasonable steps, but that isn't a reasonable approach, and not a prompt approach to addressing the problem, addressing the issue. As in all of these cases, all of the first instance case, they are all very fact specific, and they all turn on the entire chronology as to how that is to be interpreted in the context of the behaviour of the instructed solicitor. And in my submission, they have acted promptly and unreasonably in the manner in which they made the application to extend. It could have been made earlier, I accept that. But there's nothing in the date that it was made that does constitute a lack of promptness when one looks at the date of the service and the repeated assurances.
Of course, one of the advantages, if the application had been made earlier, is that would have been a way of notifying the appellant of the claim, because the appellant didn't know about the claim until well into June, so weeks and weeks after the deadline expired, whereas that would have been addressed if the application to extend time had been made immediately after the expiry of the deadline, say.
Yeah, in practical terms, that's a fair point, but the reality of that is it wouldn't have made any difference, because there's nothing the appellant could have done in the context of the claim until the sealed claim form was filed on them, because there were no proceedings.
No, but they would at least have known of its existence.
Yeah, but even knowing of its existence doesn't necessarily provide any assistance to the appellant or respondent or defendant in these matters. Just being made aware of it, it would have had no practical benefit other than knowledge. That nothing that could have been actioned until the sealed claim form was served.
So it might be said that that's the point, that if you ask why do the rules require promptness, the reason might be so that the other party is given knowledge that although a deadline might have expired, there is at least a possibility that someone is trying to get an application to allow that deadline to be extended, so you're aware of it. That strikes me that may be why there's a rule that requires promptness in the first place, is for the benefit of the other party. What's your reaction to that?
Again, it would inform the other party that application or that process is underway, but nothing would happen. Nothing even on that basis. Nothing would happen until the claim form was served. It was issued and served, because the application couldn't be determined anyway, because whatever the extension period that was required would not be known. And it's just, in my opinion, it's a slight oddity in that what is necessary is an application that asks for an extension to a certain point, which is not known until the claim form is served. And until that point, nothing can be done on either an application to extend or the statutory review anyway. So yes, it would inform the other parties, not just the Secretary of State in this case, but the local planning authority. But it wouldn't engage anything other than we know. There still has to be a final point at which the wheels start to turn. So yes, I accept that the other parties, maybe they would have liked to have known, and indeed did know at one point in June throughout the process before the sealed form was issued. But even then, having known about it, nothing could be done. So in my submission, I'm not sure where that would go to in terms of the necessity for promptness being related to and only to the date of the deadline date, because nothing can be done in the intervening period. In my submission, the requirement for promptness is an ongoing requirement, and it should specifically apply to in these circumstances anyway, how soon after the claim was issued that the application was made.
I suppose you could say that in part at least a corollary of promptness is certainty, or a degree of certainty about the intentions of the would-be claimant. So that if I'm a developer who's got a planning permission and that's being challenged, I know where I stand so far as commitments are concerned. If I'm a local planning authority that is the authority that's made the original decision, and there's a challenge which may or may not crystallise in a properly constituted, issued and served claim, then at least I know where I stand to that degree. And it does, because planning has these ramifications for those involved, both developers, authorities, and indeed also third parties, that certainty has always been regarded as very important in planning. And promptness is, in a sense, a manifestation of that. The test of promptness is a manifestation of that. Is that a fair comment or not?
Yes, I think it is. Clearly, the requirement of certainty in the planning sphere is an important matter, which is why the deadlines for bringing such challenges accelerated over and above judicial reviews, etc. One might think there would be provision within the rules for notification of such challenges, either in advance of filing or at some other point where issue hasn't properly occurred, but there isn't. I'm not sure in my submission it would be right to then try and import that into the determination of what promptness amounts to in an application for an extension of time.
Right. Thank you.
So they, in my submission, they are the general background facts of the different authorities before your lordships and the current case. That the learned judge, I won't spend any time on it. She does acknowledge the good law principles, sets out the facts. She expressly references in the judgment prejudice to the appellant. She recognises the repeated, the frequent contact with the court. She does expressly recognise, reasonably so, my submission, the respondent was entitled to reasonable expectation that they would receive the claim form before the deadline. She does deal with all of the principal issues. She finds that there's paragraph 12, the failure to serve the documents was outside of the control of the respondent, that the behaviour in chasing was reasonable. She just find importantly, I do make this point, that the delay did not stem from the use of the wrong claim form. Your lordships will see that Practice Direction 54D at 4.2 references merely Part 8 claim form.
I don't think that was a point that Mr. Fry was taking now, the question of the incorrect.
Okay, that's fair enough. I just wanted to make that point. As I said, the judge recognised that the claim form email was sent with high importance, as was the chasing email. Continued chasing, which spoke of the urgency, and she did quite reasonably in my submission, it was difficult not to have sympathy with the respondent in these circumstances. In my submission, the approach of the judge is entirely reasonable and the conclusions measured, and it's within the ambit of the discretion that was available to her. She didn't stray outside of the relevant test, and she addressed all of the relevant matters. And the discretion is a wide discretion. Just turning briefly to the two grounds. I've actually covered most of it anyway, so don't use it.
I was going to say, I'm sure there may be other things you want to say, but certainly my notes suggest that you've covered both of the grounds.
There's a couple of mine.
Unless you have some rip roarers, Mr. Rudd, that you are about to unleash.
I don't, and so I can do it very quickly. I do like to think I have some rip roarers, but that's really a matter of your judgment, not mine.
It's very direct and clear, Mr. Rudd.
So ground one, I do. It's basically that my friend says that the judge was wrong to find that the respondent took all reasonable steps. I've explained why, in the context of Telford and Wrekin and finding in good time, that all reasonable steps were taken. In the Farnham Town Council case, the judge does say what one can look at the overall context. You can perhaps bring that up. It's paragraph 1, 2, 3. First authority in the bundle. The case law makes it clear that there are various factors to be considered by the court in deciding whether to exercise their discretion to extend time for service. They include the amount of delay, the reasons for it, the prejudice to the parties if an extension is granted, the overall merits of the claim, and an overall appraisal of where the interests of justice lie. All must be considered. No one factor is determinative. So this is an exercise of discretion. So it is a fairly wide-ranging consideration. And in my submission, that there was no meaningful delay between issue and service, and no meaningful delay between service and application to extend. In the context of the overall merits of the claim, which the court, their comment can be taken into account, your lordships will be aware that Her Ladyship
Lady
did.
Justice Carr said you can't.
Yeah, I understand that, yeah.
You don't take into account the merits.
no, but this is a wide-ranging, this is a wide discretion that is being applied. And it would be, in my submission, artificial to ignore entirely the merits of the claim. And the merits of the claim are not something that I'm going to argue. All I'm really going to say is that Her Ladyship did grant permission to proceed to challenge on one of the grounds. And that's as far as I take it. And in terms of the interest of justice, there was no serious delay in my submission, especially when one compares the chronology to the 6 or so authorities before your lordships, where there was serious delay caused by the tardy behaviour of the claimants in those cases seeking to commence proceedings on or immediately before the deadline. It is difficult in my submission, when considering the interest of justice, to potentially condone the actions of the Administrative Court Office in Manchester, which really are, however one looks at it, unacceptable. And your lordships will be aware that when considering the interest of justice, this challenge, the wider challenge, the statutory review, relates to people's homes. It is fact specific. I do say that the balance does tip in favour of extending time, as the learned judge found. On ground 2, I can be brief. Essentially, my own friend claims that the learned judge failed to take into account the substantial prejudice caused to the Secretary of State. Well, setting aside that prejudice needs to be balanced against, in my submission, the prejudice caused to the respondent in this case as a consequence of the actions of the Administrative Court Office. The learned judge does expressly reference it at paragraph 7. It's not something that's absent from her judgment. It would be, in my submission, inconceivable, having been addressed on that point, and it was a principal point in terms of the Secretary of State's arguments, for her to reference it and then completely absent it from her balancing exercise. So my submission, she has taken that into account, and she has taken it into account in a proper exercise of her discretion, the court's discretion to extend time to serve the claim for. Unless I can assist your lordships any further, I don't have anything further to say on those 2 rounds of background.
Thank you very much. Thank you very much, Mr.
Thank you, Lordship.
Now, Mr. Fry, do you have a reply?
My lord, I'm very conscious of the time. May I have...
You're under no time pressure. I just want to know whether you've got a reply, and if so, how long you think
I have 5 minutes. If it's not pretty and I really go through the points as I've jotted them down, my lord, that would speed things up, and I appreciate the time is up.
Yes, but do not feel under pressure. You're not under pressure.
I'm very grateful.
I simply wanted to get an idea of how long the reply would take.
I'm very grateful. My lord, it is simply clearing up a few factual matters and answering some points the court raised, so I'll move as quick as I can. The first point, my lord, the court, we've looked at already, but we looked at the various emails which were sent to the court in what I say is the relevant period between April and the 2nd and 4th of May on 98 and 99 of the core bundle. My lords, it's only really an observation that my learned friend's quite correct. It does mention section 288 and section 289, but nowhere in either of those emails is any indication as to what the date is, how long we've got. This could have been submitted on the first day of the 42-day period or on the last day. The court doesn't have that information. My learned friend's answer is that that was a matter for the court, and the court needed to analyse what the deadline was and act accordingly. My submission on that is that that's putting quite a lot on the court office, who aren't specialists in these particular claims and aren't to be expected to know all the permutations of time limits and so on, which, as my lords are well aware, is a heavily litigated area. There would be considerable risk for the court if it was the case that the court was obliged to look at a claim and work out what the deadline was, having not been told, and to act accordingly with that deadline that it then worked out. My lords, staying within the bundle and what the court knew and what the claimant knew at various times, on page 116 of the bundle, my lords have an email there from the Administrative Court Office from Mr. Hand, which is explaining exactly that confusion, my lord, saying that the claim form confused the court. There was no indication which was for the 288, which was the 289, and that's why we were confused. Except, of course, that this is in July, and there was opportunities for the court to clear up that confusion. But then moving back in time, just to deal with the point that there was no claim and there was no claim reference until July. If my lords look at claim bundle page 110, there's an email from the court on the 15th of June 2023, which provides the case references. So at the very worst, at least on the 15th of June, the claimant knew what the claim references were, if that is indeed a reason why one doesn't need to make an application for an extension of time. There was a question from my lord about the whether or not there was a reasonableness test within CPR 763C. My lord, my response would be, perhaps there is, to the extent that it is discretionary, but certainly there's nothing in the plain language 763C which imports a reasonableness test, and the plain meaning of promptly, that can be contrasted against 763B, which does make explicitly that the steps that to be taken must be reasonable. So the draftsman clearly could have put in reasonable promptness in 763 if necessary. And addressing briefly the point about the oddity, as my learned friend put it, about making an application for an extension of time. I'm not sure that troubled the court, but to the extent it did, it was perfectly possible in my submission to make an application for an extension of time on the basis that time is extended until 4 days of issue of the sealed claim form, or words to that effect. That's entirely normal, and I've certainly seen orders to that effect previously. So one doesn't need an absolute date. One could have a flexible date within one's order, and that would achieve all of the effects that were raised in respect of putting the applicant on notice. Although I'm also bound to say, my lords, I don't think it is appropriate to put the applicant on notice by some other way. It is the sealed claim form which is the foundation of the claim, and I don't want the court to be misled into saying that there's some other test or some other action that should be taken. The last point, my lords, as a duck under the line, is my lords were taken to the judgment again, and the chain of logic that Her Ladyship adopted below. My lord, all I'd ask the court to look at is on claim bundle 47, paragraphs 10 and 11. As the judge goes through her analysis, she is plainly taking into account all of the steps taken after the expiry of the deadline before reaching her conclusion, for the reasons I set out earlier. That approach, I maintain, was wrong. My lords, that's all I had to say in respect of submissions. Unless I can assist further, there's the administrative point that I'm going to address. My lord, yes. I'm grateful. While my learned friend was speaking, I've tried to locate the original claim form. It turns out that on email, I'm not taking a point on this, my lords, the form that is in the bundle, which is wrong, was what was sent in July in those emails. That point has not been taken before. I don't want that to be a point in this appeal. But it might be that my learned friend can assist by asking his solicitors to provide the actual sealed claim form. Certainly, my clients and I proceeded on the basis that it was correctly served on the 12th of July, but I do not have it in my files, and nor is it in the bundles in the court below. So my learned friend's solicitors might be able to assist, or my learned friend might be able to, but I don't have that document, neither does my solicitor, as far as you can tell.
Right, well, Mr. Rodder, you may well not be able to assist us straight away.
I
What
can't
I'm-
at the moment.
What I'd be minded to do is to give you until noon tomorrow to supply the answer.
Yeah,
And only that.
that should be sufficient.
Matter of fact.
It is a form that the court have issued. My solicitors must have it.
Yeah. You happy with that?
Yeah, absolutely fine. Yeah. But,
So,
right to raise.
no, quite right. I mean, it was right for us to raise it for obvious reasons. So if you would please assist the court in that way by 12 noon tomorrow.
Yes.
Thank you very much. Really grateful. So, that concludes the hearing. Thank you both very much for both written and oral submissions that were clear, well directed, and made very good use of the time available. We're grateful always for such advocacy, and we want to pay tribute to it. Thank you very much.
Thank you.
You've given us enough to think about that we're going to reserve our judgment. That will be provided to you in draft in the normal way in due course. At that stage, for typographical and any minor factual errors only to be corrected, for a draft order to be agreed and presented to the court, and at the same time, please, any consequential submissions that may be necessary. There will be an embargo in the normal way attached to the draft judgment. That has real consequences for those who do not comply with it. I'm sure that everyone will bear that in mind. Thank you very much.
Thank you, Lordship.